Greetings, my name is Kushagra Singh, student of BCom LLB third year, and today I am going to present on the topic layoff and retrenchment under Industrial Relation Code 2020. This is my Labor Law 1 class presentation. So the agendas which we are going to cover in the today's presentation are historical evolution and constitutional framework, layoff and legal analysis, retrenchment legal framework, judicial interpretation, and comparatively analysis. So now, first, there is historical evolution of layoff and retrenchment. Now, before the year 1953, there was no statutory compensation for the layoff. So, before 1953, workers who were laid off due to the reasons beyond their control, like shortage of raw material or machinery breakdown, had no legal entitlement for the compensation. Employer-employee relationship were governed by common law principle and standing order under the Industrial Employment Standing Orders Act 1946. This means the compensation was dependent on what is specified on the contract or interpreted by judicial decision, not as a matter of right. So this was changed in the year 1953. The Industrial Dispute Ordinance 1953 was uh, was enacted, marked the first statutory acknowledgement of layoff compensation. The key features included workers laid off not due to the fault of their own were entitled to compensation equivalent to 50% of basic wages and dearness allowance. This aimed this aimed this aimed to balance employer operational constraints like shortage of power and natural calamities with workers' livelihood. Recognize the layoff as temporary suspension, not the permanent termination. Now, after the Industrial Dispute Act, the IR Code, IRC, Relation Code 2020, was passed. The IR Code 2020 subsumed the Industrial Dispute Act 1947. The the major updates regarding the layoff were the layoff the provisions of layoff were largely retained but with updated threshold. Now applicable to establish Now they are applicable to establishment employing over 300 or more workers. Earlier it was only 100. Compensation mechanism remains similar, but reform aligns with ease of doing business policy while retaining workers' protection. Unified framework for layoff, retrenchment, closure, and dispute resolution were also added. Now, policy arc. The historical trajectory reflects a dual motive, recognizing employers' right to recognize or adjust production due to economic condition, ensuring workers don't bear the brunt of industrial risk. Layoff compensation protect against sudden income loss. Now, constitutional framework. Under Article 19(1)(g), freedom to carry on business and occupation, the Constitution guarantees the right to practice any profession or carry on any occupation, trade, or business. For employers, this include managerial autonomy like deciding workforce size, production schedule, and business restructuring. Layoffs are part of this managerial uh, prerogative. Now, under the Article 19(6), reasonable restriction in public interest. These provisions allow the state to impose restrictions on business freedom to protect worker and maintain industrial peace. Laws regulating layoff, retrenchment, and closure, such as prior permission, compensation mandate, and last in first out LIFO rule, are justified as serving as larger public interest. Under Article 21, Right to Life and Livelihood, employment has been read into right to life with dignity. Court emphasized that losing a job isn't economic loss, it's affect dignity and human dignity and identity. Hence, even in layoff or retrenchment, workers' protection like compensation are seen as essential to this right. Now, judicial precedent are Excelsior versus Union of India 1979. The Supreme Court held that while the right to close down business is part of Article 19(1)(g), it can be regulated in public interest under Article 19(6). Workmen of Meenakshi Mills versus Meenakshi Mills 1992. The court upheld the provision regulating government permission before retrenchment closure, affirming that these safeguards ensure fairness and social justice. So these constitutional framework also define and help in structuring the labor code. By this, the both employer and worker have the right have their right protected. Like like the employer have the right to lay off the workers in the slowdown of business, so he or she don't suffer a major loss. But worker also had a right ki even in the layoff they don't deprived of getting salary, which can hurt their livelihood. Now, layoff statutory definition under Section 2T IR Code 2020. So, the definition is layoff means the failure, refusal, or inability of an employer on account of shortage of coal, power, raw material, accumulation of stock, breakdown of machinery, natural calamity, or any other connected reason to give employment to worker whose name is on the muster roll and who is not been retrenched. Now, what this definition means are as follows: temporary suspension of work obligation. A layoff is not a termination, it is a temporary halt in employer's default duty to provide work and employees guarantee to work. It implies as pause is not a end in employment contract. Employer's failure, refusal, inability to provide work. Layoff typically occur when employer cannot give work due to reason beyond control such as shortage of power, breakdown of machinery or natural calamity. It is not based on employee misconduct or fault. Worker must be on muster roll. To claim layoff compensation, the worker must remain record on muster roll, that is attendance register of the establishment. This shows their employment continuity and eligibility. Worker must not be retrenched. Layoff should not be used as disguised form of retrenchment. Once retrenched, a employee ceases employment and cannot claim layoff benefit. Statutory safeguard prevent employers from misusing layoff provision to evade retrenchment compensation and procedure. Now, layoffs key element: employer originated cause. The trigger for layoff must arise from employer side, such as a shortage of raw material, power cuts, or machinery failure, not from any misconduct or fault of worker. This fundamentally distinguishes layoffs from disciplinary action, where employees are suspended or fired for violating workplace rule. Second, temporary suspension. A layoff is not a termination, it is a pause in work with intent that normalcy will resume. The employment relationship kept alive even when actual work isn't being done. Statutory ground. Laws like the Industrial Code 2020 lay out specific grounds for declaring layoff. This include reasons like financial stringency, raw material scarcity, and natural calamity. Court have also accepted analogs or connected reason where the underlying logic is similar. Muster roll presents the to qualify the layoff benefit, the worker must be registered on the establishment muster roll, meaning they are still formally employed even if temporary without work. Being on these rolls reflects the continuity of the employment relationship, not retrenched. A layoff is distinctly different from retrenchment. Retrenchment is a permanent termination of employment with its own procedural and compensation requirements. Layoff being temporary do not terminate employment and so cannot be used as a covert method of retrenchment. Statutory protection. Worker laid off validity are entitled to compensation under law, typically 50% of basic wage and dearness allowance during the layoff period. This protection ensures they are not left entirely without income during industrial downtime. The grounds for layoff: enumerated and residual. Enumerated statutory ground: shortage of raw material, this is supply chain disruption affect production input. shortage of power या coal, energy resource constraint halting operations, accumulation of stock, excess inventory preventing further production, breakdown of machinery, technical failure requiring operational pause, natural calamity, force majeure event impacing operations, residual ground and scrutiny. Any other connected reason must be analog to enumerate grounds. Judicial interpretation must be beyond employer's control, must not be attributed to employer's malified intentions or malified activities. Scrutiny standard: employer must evidence the ground claimed. Financial difficulties along with proof insufficient cannot be employer's own mismanagement. Now, operational criteria present 2 hour rule या half day. Worker presence requirement. To qualify as laid off under law, worker must report to workplace during regular working hour. It's their physical presence that trigger ability for layoff compensation. The law presumes willingness to work, and it's the employer's inability to provide work that activates statutory remedies. 2 hour rule. If worker reports on time but no work assigned within the 2 hour, they are considered deemed layoff. This rule prevents employer from avoiding layoff liability by merely keeping the gates open without actual work. Em- Employer must track when worker arrived and whether work was offered or declined. Half day proviso. If work become available and the worker is called for the second half of shift, they are treated as laid off only for first half. Compensation then adjusted typically 50% for the half day. This reflects fairness. Workers are paid for the time they weren't provided work but aren't overcompensated. Documentation required. Employer must maintain muster roll with time for arrival and departure, records showing work allocation and inability to allocation of work, evidence supporting layoff claim in case of worker dispute and labor inspection. This documentation safeguard both parties. Workers can claim rightful compensation and employers can be provide compliance. Layoff procedure, small medium establishment. uh, so this is a layoff procedure for small and medium establishment like the small scale industry. Determine applicability. Layoff provision apply to non seasonal industrial establishment with more than 50 workers employed on an average in precedent calendar month. Identify statutory ground. The layoff must be due to specific reason like power failure, raw material shortage, machinery breakdown, stock accumulation, natural calamity. Verify eligibility worker. Only worker who are on the muster roll in continuous service for at least 1 year or 240 days are not retrenched qualify for and not retrenched or qualify for layoff compensation. Document and notify. Employer must record reason for layoff, maintaining proof, and inform the union or worker committee if applicable. Provide compensation if workers are entitled to 50% of basic wage plus DA payable for up to 45 days in a 12-month period. Now, layoff compensation and duration under Section 67 of IR Code 2020. Statutory compensation amount. The workers are entitled to 50% of basic wages plus dearness allowance for each day they are laid off. Maximum duration without retrenchment. Laid off compensation is capped to 45 days in 12-month period, after which the action must be taken. Employers' options after 45 days are procedure to retrench, which following section 70's requirement include notice, compensation and government notification, or reach a mutual agreement between workers and union. Eligibility criteria: only worker with 1 year of continuous service as defined in section 66 are entitled to layoff compensation. Now, continuous service section 66 deemed inclusion. Threshold requirement: a worker must have completed 1 year of continuous service to qualify for laid off compensation, ensuring protection for long term and regular employees. 240 days 190-day rule. Even without a full calendar year, a worker is deemed to continuous service if they have worked in 240 days factories and establishment and 190 days in mines during the preceding 12 month. Legal fiction: a law creates statutory fiction where certain interruptions are ignored to preserve continuity of service, treating these as days worked. Deemed service inclusion: layoff days, weekly off and paid holidays, AIBE versus Corporation of India, it was held. Authorized leave period, lawful strike days, lockouts not attributed to work, and maternity leave, up to statutory ceiling. Workers not entitled to layoff compensation under section 69. Refusal of suitable alternative employment: if worker refuse for alternative work provided by employer within 8 km of establishment, same wage offer and no higher skill required than regular work. Absence at muster roll signing: a worker must report and sign the muster roll at scheduled time to eligible. Not showing up means they are treated as absent, not laid off. Strike include laid off. If layoff result from strike or go slow in any part of establishment, compensation can be denied to workers in other department, which was held in case of ACC versus Workman 1959. A worker is one unit where denied compensation became because of strike in another unit disrupt production. These exceptions ensure layoff benefit aren't misused and reinforce worker responsible during disruption. Now, large establishment prior permission regime. This is governed under section 77 to section 83 under IR code 2020. This applies to the large establishment with 300 or more workers. So applicability: layoff permission requirement applies to industrial establishment with 300 or more workers employed on average in previous 12 months. Permission requirement: employer must obtain prior written permission from the appropriate government before laying off any worker except in case of natural calamity. Application procedure: a detailed application must be filed stating the reason for layoff, showing it is genuine, necessary and compliant with the legal procedure. Union or worker representative should be consulted. Government decision: the authority examining the case may hold an inquiry and must issue an order approving or denying permission within 60 days. The decision remain valid for 1 year and must be reasoned. Consequence for non-compliance: if employers lays off worker without permission, the layoff is illegal. The workers are entitled to full wage and employer may face penalties under section 86 of this act. The court can also order reinstatement. Layoff key case law: like there are key case law which deals with the layoff are Workman versus Workman of Devat Tea State versus Management 1964. The Supreme Court held that the layoff must strictly fall within the statutory ground. If an employer uses layoff as a mark for retrenchment, it is illegal and liable to be invalid. Associate Cement Company versus Workman 1959. The court recognized that the strike in a feeder or linked establishment can disrupt operation and justify layoff in another unit. Workers are denied compensation due to statutory exception. General Engineering Work versus State of Rajasthan 1976. The court ruled that mere claim of financial difficulty are not enough. Employers must provide evidence to provide bona fide layoff grounds. SBI versus N. Sundarmani 1976. The Supreme Court emphasized the definition of layoff and related terms must be constructed liberally in favor of employee to prevent employment from bypassing legal protection. Now, layoff illustration: in the case of shortage of raw material, their example ABC Textile, a industry faces supply halt of cotton due to political unrest. Workers report for duty but cannot provide work. So legal analysis: under this is valid under section 2T of IR code 2020. Shortage of raw material, employer demonstrate bona fide cause. Outcome: valid layoff, worker entitled for 50% wage compensation under section 67 in meeting continuous service criteria. Like partial layoff, this is half day. Like chemical layoff worker for half day due to power outage in segment. Worker called for second half and given work. Legal analysis proviso in section 2T of the act. Half day layoff permitted when worker provided the latter part of shift. 50% of basic wages and DA for half day in this kind of layoff may be provided. And there are more examples, and few more illustrations are uh, large establishment without permission. Factories with 500 workers declares layoff without seeking prior approval under section 77 and 79. The layoff deemed invalid, full wages payable, and potential penalties under section 86. And there are more examples. Now, retrenchment. Its definition is given under section 2ZH IR code 2020, which rate retrenchment means termination of worker service by employers for any reason whatsoever other than punishment inflicted by disciplinary action, voluntary retirement, superannuation, non-renewal of contract, completion of fixed term employment, or termination due to continued ill health. Now, residual nature definition. The legal definition of retrenchment is intentionally broad. Any termination of service by employer, unless falls within the specific statutory exception, is presumed to be retrenchment, ensuring wide coverage. Employers initiated termination. The label used by employer, this is relieving, discharge, or closure, won't matter. Court apply the substance over form principle to assess whether the termination is indeed retrenchment. Now, leading judicial interpretation in SBI versus N. Sundarmani, the court held the retrenchment include every termination other than exception exceeding the concept beyond everyday usage. In Robert D'Souza versus Executive Engineer, the court ret- reiterated that any termination not explicitly excluded, even from reason like non-renewal of contract, is treated as retrenchment under the law. Now, what is not retrenchment? Statutory exclusion. Disciplinary termination. If worker is fired because of mixed concern like theft or insubordination after proper inquiry and chance to defend themselves, it's not retrenchment. It's penalty under disciplinary rule. Voluntary retirement. When worker choose to leave the job early, accepting a voluntary retirement scheme VRS offered by employer, it treated as voluntary exit, not retrenchment. Superannuation. This is normal retirement that happen when worker reaches a preset retirement age like 58, 60 or 62. No retrenchment compensation needed because it's natural end of employment. Contract compensation. If someone is hired on fixed term contract, say for 1 year, and the contract ended, they aren't retrenched. The job ended as agreed on the contract. In the case of MD Karnataka Handloom Development Corporation vs Mahadev, the court confirmed that non-renewal of fixed term contract isn't retrenchment. Medical grounds. If worker is let go because they are unable to work due to long term illness or disability, it falls under exception of continued ill health, so it's not considered retrenchment. Case law, Anand Bihari versus Rajasthan State Road Transportation Corporation. The Supreme Court held that termination on ground of ill health is not retrenched under the law. Essential ingredient and due process. Employer initiated termination of service. Retrenchment applies when employers end the worker's job, not when the workers resign or both sides agrees to part ways. It's employer's action that triggers retrenchment law. Wide scope of reason. Court don't just look at label like release or discharge. They focus on what really happened, whether it due to cost cutting, reorganization, automation, or business slowdown. If the employer ends the job, it could be retrenched as long as it's genuine and not hidden punishment. Natural justice compliance. The Supreme Court in D.K. Yadav vs. GMA Industries Limited 1993 held that you can fire someone automatically without fair process. Even termination clause must follow basic fairness like a chance for employee to be heard, not within the statutory exemptions. Under Section 2ZH of Industrial Relation Code lists specific exceptions like superannuation, dismissal, contract expiry. If termination doesn't fall under these exceptions, it counts as retrenchment and worker get full legal protection like legal notice and compensation. Reason for retrenchment: legal and practical. Legal ground: retrenchment is allowed when employer genuinely lead to reduce staff for reasons like economic necessity, organizational restructuring, technological change, and business shrinkage or partial closure. Judicial practice: Sabos T State 1964. The court recognized that employer can decide how many workers they need. Modern stores 1970. The court upheld retrenchment if it's done in good faith, meaning it genuine require and not cover unfair dismissal. Practical scenario: retrenchment often happen in real world situation like machine replacing due to automation, two department merge and some role become redundant, falling customer demand make unsustainable to keep all workers, financial trouble force the employers to cut cost by reducing staff. Important consideration: the employers must prove the retrenchment is genuine, not just pretext. If the retrenchment is done with bad intent, just malified or to target certain works, it's illegal. Court inspects such case carefully to prevent employer from using retrenchment to hide unfair dismissal. Now, precondition for valid retrenchment under Section 70 of IR Code: 1 month notice or wage in lieu. That is, before retrenching a worker, employer must either give written notice of 30 days explaining the reason or pay wages instead of notice, known as wage in lieu. Retrenchment compensation: the worker must pay compensation equal to 15-day average pay of every year of service for part year over 6 months. This is based on the formula. This is a formula. Notice to government: the employer must also send formal notice to appropriate government authority with full detail of retrenchment in prescribed format. Cumulative compliance: these three requirement, notice, compensation and government intimation, are all compulsory. If any step is skipped, the retrenchment become invalid in the eyes of law. All three conditions are mandatory and cumulative. Bombay Union of Journalists versus State of Bombay. This was held in this case. Now, retrenchment compensation calculation and timing. Statutory formula: retrenchment compensation calculated as 15 days average pay of every year of service. Even if worker has worked more than 6 months in year, it counts as full year. Average pay calculation compensation of the formula is monthly wage divided by 25 into 15. Timing of payment: the compensation must be paid at the time of retrenchment. If delayed, the retrenchment can be treated invalid. Continuous service eligibility: if workers qualified, if they have worked at least 240 days in 12 months before retrenchment. In Vlixen Buckwell India Limited versus Jagannath 1978, the court held that temporary workers are eligible for claiming retrenchment compensation. In J. Reddy versus Railways 1975, it was held that casual workers can also claim retrenchment benefit if they show continuity of service. Now, large establishment permission regime: 300 workers. This is also in section 77, 78, 79 of IR codes 2020. Government permission required: employer must get prior written permission approval of the government before retrenching any worker. 3 months notice, a 90-day notice period or wage in lieu must be given instead of usual 1 month notice. Without permission, this is illegal. Any retrenchment done without government approval is invalid. Full wages payable: if retrenchment is illegal, the worker entitled for full wages as if still employed. Workmen of Meenakshi Mill Limited was a Meenakshi Mill Limited. The section 25N, now section 79 of IR code, held constitutionally valid requirement for prior approval and reasonable restriction under article 19(6) to uh, to protect workers in large industrial unit. Rajendra Singh Chauhan was a state of Haryana. Supreme Court upheld constitutional validity of retrenchment restriction for public interest, balancing employers' right with large socio-economic welfare goals. The last come first go, section 77 and exception. LIFO principle means that the when retrenchment happen, most recent hired worker in particular category must be first to go. Statutory basis, this rule built into Section 71 of Industrial Relation Code 2020, making it legal obligation for employee. Purpose: LIFO avoid favoritism. It ensures senior workers with longer service aren't unfairly removed when company trims staff. Permissible exception: any employer that can retain junior worker over senior one if there's a valid reason such as special technical skill, better performance or efficiency, qualification required for ongoing work. Procedural safeguard: if any employer deviates from LIFO, they must record and justify the reason, which can be reviewed in case of dispute. Case Swadesh Mitran Limited versus their workmen held insufficiency or unreliability can justify department from LIFO, but employer must demonstrate valid grounds. Reemployment right and retrenched workers, section 72. Preference in reemployment within 1 year: if company needed to hire for similar job within 1 year of after retrenchment, retrenched worker get first preference. Worker must offer themselves. This right works only if worker applies or show interest in rejoining. It's not automatic. Right for preference, not guaranteed position. The worker get priority in consideration but isn't guaranteed job. The employers must consider them first but can choose someone else for valid reason. The retrenched worker may not return to the same post or salary. They could be offered lower or different role depending on the company needs. Employers obligation: maintain recall roster or of retrenched worker, notify eligibility ex worker of vacancy. In the case of Delta Wire Private Limited versus General Labor Union 1995, retrenched worker can claim preference in reemployment but not necessarily the same position or benefit they had earlier. Now, consequence of invalid retrenchment. Under Sunendra Kumar Verma case, the Supreme Court held that if retrenched illegal, reinstatement is default remedy. Employers can't replace by only offering compensation. Baldev Singh was in Labour Court, Chandigarh. If the employers violate Section 25F, now Section 70 of IRC, retrenchment is void from start. The worker must designate with full back wage. Now, conversion from layoff to retrenchment: 45-day maximum without further action. Under section 67, if worker has been laid off for 45 days in a year, the situation don't improve, the employers can start retrenchment. Procedural requirement must be followed. The retrenchment must comply with section 67, include notice or wage instead of paying retrenchment compensation, and sending official notice to government. For big establishment, 300 more worker, there is a add up step. Employer need for prior government permission under section 78. Set of provisions: the employers must adjust the layoff compensation already paid against the retrenched compensation, so the worker don't get paid twice for the same period but still receive legal minimum wages. Document requirement: employers must keep clear record like calculate payment, formal notice exchange, and prove they followed in last in first out rule if retrenched multiple workers. Retrenchment landmark cases: SBI Robert D. D'Souza was executive engineer Southern Railway, DK Yadav was a JML Industry, Bombay Union Journalist was a State of Bombay, and Excelsior was a Union of India. Now, retrenchment illustration: in the case of no notice of compensation, for example, Rohit, a employee with 3 years of service, is terminated due to decline in export order without notice or compensation. Legal analysis: violates section 70. Requirement: notice, compensation, and government requirement. Outcome: termination void, entitled to reinstatement with continuity and backup wage. And these are some more. And violation of LIFO principle scenario: senior employee with 10 years service retrenched with junior employee 2 year retained without recorded reason. Outcome: prima facie legal retrenchment. Court may order restatement with back wages. Swadesh Mitra Limited was a workman. Now, the difference between layoff and retrenchment. Layoff is temporary suspension of work, but retrenchment permanent termination of employment. Shortage of material power, cost, shortage of material power, breakout, and natural calamity. Retrenchment, business reason, recognition, and employee economic necessity. Statutory basis, defined under section 2T, defined under section 2ZH. Worker stature: remain employed but not given work. Retrenchment: employment relationship terminated. compensation of 50% of basic wage plus DA in retrenchment, 15-day average pay for each completed year. Now, policy rational and balancing interest, employers' freedom versus worker security, graduate regulatory framework, industrial peace and procedural predictability, and constitutional underpinnings. Now, these are the comparison with India and UK and US worker code. These are the comparison. Uh, in India, there is temporary suspension means layoff and permanent means retrenchment. UK redundancy framework, no distinct layoff concept. In US, mass layoff and plant closing regulated. Compensation in India 50% of wage in layoff and retention 15 days per year. In UK, statutory redundancy pay based on age, pay, and length of service. In US, no statutory compensation, focus on notice. Notice period in India 1 month regular, 3 months in 300 or more worker. UK 1 week per year of service, 1 to 12 week. 60 days of advance notice for mass layoff in US. Government permission required for establishment with more than 300 workers in India, not required consultation with union and representative. In US, not required notice to state authority only. So by this I end my presentation on the topic layoff and retrenchment under Industrial Relation Code 2020. Thank you.